So good morning, everyone. Thank you so much for joining us either in person or online. I am Juliana. I am a postdoctoral fellow at the University of Cambridge Center for Gender Studies. And today I am delighted to be joined by basically an all-star cast of speakers. Yay. They're giving me a very hard time to actually present them without just basically speaking for 30 minutes because they all have achievements and achievements and achievements. So I'll try to be as brief as I can. But today, firstly, we're joined by Professor Valerie Oosterveld, and I'm trying to keep it together, not to fangirl over her way too much because I have already done this. But she is Professor of Western Law and Western Research Chair in International Criminal Justice. I've been citing her crazily in my research for quite some time because she was also part of the Canadian delegation that was at the negotiation of the Rome Statute and was very much working for the gender definition for the Rome Statute, which we're going to be discussing a little bit about today. But she didn't stop there, of course. She is a member of the, she wrote a lot. She was also awarded a prize of the American Society of International Law for a book that was also edited. It was an edited volume with Susanna Sakoto, which is I also know, and which, she's great. And she's also been doing a lot of research in space law. And I was like, how? Why?
But space law needs a feminist interpretation.
It definitely does. So thank you so much. So thank you so much for joining us today. We're also joined by Dr. Rosemary Gray from the University of Sydney, who is a senior lecturer and the co-director of the Center for International Law. Her work focuses on international criminal law, but also especially sexual, reproductive, and gender-based crimes. She has a monograph, which I adore, with prosecuting sexual and gender-based crimes in the International Criminal Court, published by Cambridge University Press in 2019. She has published extensively on the topic that we're dealing today. And she's also one of the highly qualified publicists because she has been cited by the ICC appeals chamber in the first case on forced pregnancy. So just a little bit of like dropping there. And we're also joined by Alexandra Lily Cather. There are a wonderful and amazing human being and activist in international criminal law, and also just like the greatest expert you will ever see in international criminal law. They work in the strategic investigation and prosecution of intersectional dimensions of violations of international human rights law, international humanitarian law, international criminal law. Their work specializes on gender-based and slavery crimes. They have advanced a successful prosecution of rape and sexual coercion as crimes against humanity in government-run detention facilities in Syria, in the Anwar case in the Higher Regional Court of Koblenz in Germany, and the first ever successful prosecution on persecution intersecting grounds of religion and gender of the Yazidi in the Sarah O case in the Higher Regional Court of Düsseldorf, Germany. They are part of the Justice Rapid Response roster and also of the Emergent Justice Collective. And I'll stop there because I can go on and on and on. And we're also joined by the wonderful Akila Radhakrishnan, she's also an amazing international human rights lawyer and a globally recognized expert in justice and accountability. They have led groundbreaking legal work on gender international law, including abortion access in conflict situations. She has also briefed at the United Nations Security Council and at the International Criminal Court, and she regularly advises government and multilateral institutions on the issue of gender equality and human rights. They are now with the global, sorry, I am lost in the many accolades of my speakers, but it's the Global
Atlantic Council.
Sorry, it's the Atlantic Council. Jesus Christ, I am the worst presenter of all, but it's with the Atlantic Council. And thank you so much for joining us today. I believe you're in Thailand, but I told everyone you were in New York, so I'm sorry. So yeah, thank you so much. And I think I'm going to stop here. And I think the proposition for us today is really to talk about, because if you don't know, feminists are different. Because a lot of people like to clump us together, but that's not the case. So we're all here talking about the gender definition for International Criminal Court, its developments, and also the challenges that we face today, especially in relation to the new Crimes Against Humanity treaty that's been drafted. You have the drafts from the International Law Commission, and now it's up for negotiation by states. And just as we had back in 1998, a fierce debate on how to define gender for the treaty, we're now facing the same, not the same challenges, but also, again, a very fiercely debated arena on how to define gender for the Crimes Against Humanity treaty. And what I think we all bring today are not only different perspectives on the issue, but different experiences for that, right? We have differently positioned feminists that I really wanted for us to discuss and talk about what we think are the main challenges and strategies that you, from all your different perspectives and different experiences, think that we should be discussing in light of all of the challenges we face. And for now, I will stop talking and leave my wonderful speakers to talk. So please, Professor Oosterveld, the floor is yours.
All right, thank you so much. So Juliana asked us to begin by answering this question. How would you describe yourself as a scholar or activist on the conceptualization of gender in international criminal law and where you fit in? So I'm going to start off with some thoughts in that direction. And I am a scholar and an advocate for a multifaceted, complex, and socially constructed understanding of gender. And let me give you a few comments looking back and then looking forward. So I've been working in this field for a very long time, since the mid to late 1990s. And I was a young lawyer at the time, and I was volunteering with a group of amazing scholars and activists who were tracking the gender-related developments at the international criminal tribunals for the former Yugoslavia and Rwanda, which were relatively new at the time. And what they were aiming for was very simple when you look back at it from our perspective of today. And it was simply gaining recognition of sexual violence crimes as a first initial step in gender sensitivity. Because at that time, there was not within those two tribunals a sophisticated understanding of gender except amongst certain people. And sexual violence crimes were being downplayed or completely overlooked for various reasons. And we were tracking this and also trying to bring to the public's attention this basically ignoring of sexual violence crimes, because we thought this was the first step that we could push on. Then I became a graduate student at Columbia Law School in New York in 1997. And I was asked to join the Women's Caucus for Gender Justice on behalf of a Canadian human rights non-governmental organization. And this was a caucus of organizations that were gathered around the negotiations for the Statute for an International Criminal Court. And they wanted to monitor and contribute to the negotiations on the Rome Statute of the International Criminal Court. So within this coalition, it was a fantastic place to be as a graduate student, because the understanding of gender, the conceptualization of gender was very deep. It was understood as a socially constructed norm, and that gender-based violence included sexual violence, but was not limited to sexual violence. It went further and included gendered forms of targeting civilians, but also the gendered effects of war and mass atrocity. And in the context of those times, for those of you who think about the history of different armed conflicts, one of the major discussions at that moment in time had to do with the armed conflict, the very brutal armed conflict in Sierra Leone in West Africa. And in that particular conflict, there were a large number of child soldiers who were forcibly recruited. And so within this coalition, as an example of the kinds of gender discussions that we had, we were discussing the gender dimensions of the boys who were forcibly recruited. They were targeted for a particular type of child soldiering, and girls were targeted specifically for different version of child soldiering, sexual slavery, forced domestic labor, and forms of spying that relied upon gendered assumptions by civilians. So that gives you a little bit of a sense of within the non-governmental community at that time, that specific non-governmental community at that time, the sorts of discussions that we had. And then as Juliana mentioned, in 1998, I was invited to join the Canadian delegation for the final set of international criminal court negotiations. These were this was called the Rome Diplomatic Conference in Italy. And my role on the delegation was to bring a gender lens to the negotiations and specifically to focus on gender-related provisions, because by that time, there were a number of gender-related provisions that were added into the statute, because the original International Law Commission draft had no gender-related aspects whatsoever. And Canada had a foreign policy focus called human security at that time. So Canada's conception of gender going into those negotiations was as a socially constructed norm. And the view of Canada was informed by its own Charter of Rights and Freedoms, which had quite a bit of gender-related jurisprudence that had been happening in Canada, and that had pushed societally the understanding of gender within Canada that then was imported into our own Canadian position on the negotiations. But I should also mention that Canada's position on gender persecution, so persecution on grounds of gender as a crime against humanity, was as inclusive of LGBTQ plus rights because it was informed not only by the Canadian Charter, but also by history, given the persecution of gay men and the Holocaust, for example. So this was something that we were discussing within our own delegation at the time. And at the time, there was also a majority of countries in the room that were supportive of understanding gender from a socially constructed point of view, which was in line with international refugee law at the time, which had just been in the midst of a rapid set of developments, understanding gender-based persecution as a ground of persecution that qualified someone as a refugee. So let me just jump back a little bit. In that February of 1997, the term gender was included in the persecution, the list of persecutory grounds of crimes against humanity in the negotiations for the International Criminal Court. So this is why international refugee law's conception of gender persecution was being discussed in the negotiations at that time. But I'll also mention that the term gender was added in December of 1997 in a provision stating that the International Criminal Court's application and interpretation of general sources of law must be consistent with, among other things, forms of non-discrimination on grounds of gender. And when that was introduced at that time, there was broad agreement that this was a good addition into the non-discrimination provision. Now, in 1998, when we were in the final set of negotiations, we did not have a great deal of United Nations precedent in terms of the meaning of gender, because countries had avoided for a decade defining the term, including in the World Conference on Women in 1995 and the Habitat World Conference in 1996, in the UN General Assembly, in the Commission on Human Rights, and in ECOSOC. So there was no state-agreed definition of gender that we could turn to when the negotiations became very polarized, as Juliana mentioned, and it became clear that the only way out was to adopt some kind of definition of gender. We did, however, have two definitions of gender that were extant at the time in the United Nations, that were used internally within the United Nations. And those definitions had three commonalities that I just wanted to mention. First, that gender was a socially constructed concept. Secondly, that the construction of gender is complex, is influenced by culture, the roles played by men and women that they were expected to play in societies, the relationships between those roles, and the value society placed on those roles, and that the content of the understanding of gender from society to society can vary over time and within cultures. So we had two UN negotiations, two UN definitions of gender and no definitions of gender amongst states. And within the Rome Statute negotiations, while there was a majority of states understanding gender from a socially constructed approach, there was intense opposition by a minority of conservative states and conservative non-governmental organizations. And that's why the definition became such a lightning rod in the final set of negotiations in 1998. And the end result was the adoption of a definition that you might already know if you've taken a look at it. It's in Article 7.3 of the Rome Statute that says, for the purposes of this statute, it's understood that the term gender refers to the two sexes, male and female, within the context of society, and that the term gender does not indicate any meaning different from the above. And that we can get into, if you wish, the back and forth and why it turned out looking that way. But I wanted to fast forward to today. So today, so many years later, the International Criminal Court's prosecutor has a more nuanced understanding of the term gender as a social construct. The prosecutor has expressed this in a number of policies. So the previous prosecutor in 2014 in a policy on sexual and gender-based violence crimes, in 2022 on a policy of gender persecution, and in 2023 in an updated policy on gender-based violence crimes. And this policy and this approach has been expressed to judges. Now, you asked Juliana where I fit in, and that is that I agree with the prosecutor's current understanding. I've had the privilege of providing input and review, but I understand all of the arguments that are going to be put forward, all of the points that are going to be put forward by Akila, Rose, and Lily, and I take them on board because, of course, the definition of gender in international law, in human rights law, in refugee law, in international criminal law has evolved. The understanding has deepened substantially. The conceptualization of gender has deepened substantially to understanding the social construction of gender, the social construction of sexuality, and how intersectionality work together. And this evolution is important. It's to be expected. The challenge is that we are grappling with right at this moment is that the definition of gender sits simultaneously in the past, in these Rome Statute negotiations that I just talked about, in the present, for example, in the arrest warrants put forward by the prosecutor in the situation in Afghanistan, which this prosecution will be, I'm thinking positively that we will have a prosecution, is based entirely in the crime of persecution on grounds of gender. And in the future, in the draft Crimes Against Humanity Convention discussions, where the definition, there is no definition, it's been removed. So the question is, how do we balance all of these three things that sit simultaneously in international law and that have impacts on each other? And how do we keep a sophisticated understanding within the International Criminal Court, while at the same time understanding the definition of gender, or understanding the conceptualization of gender for the future Crimes Against Humanity Convention? I think I'll stop talking there because we have more back and forth that we'll have, and I'm sure that we'll have more conversation.
Thank you so much. So now I turn to Dr. Rosemary Gray. If you can start.
Ini nalawa nun mari budri gadi nurada. And then in the language of the Gadigal people whose lands I am sitting on, that's an acknowledgement that I'm on the First Nations country of the Gadi people. I want to start by acknowledging the deep knowledge in this room, on this virtual room, and also the trust that I have in each of the people that are on this convening. It was very generous of you, Juliana, to, I've never been described as a qualified publicist before, but if I'm a qualified publicist on reproductive violence, I must say, then so is Akila as well, even more so because she did us the honour of presenting our submissions to the International Criminal Court. I would also want to acknowledge here the wonderful knowledge that Valerie has brought to this discussion for decades. And I think that she embodies a deep, deep thinking about gender, dating from prior to the negotiations for the 1998 Rome Statute all the way through to the present day, where she is the prosecutor's advisor on crimes against humanity, and is also a leading voice in the negotiations for the Crimes Against Humanity Convention. And I really also want to pay my respects and acknowledge Lily, who is such a force to be reckoned with in this space. And I think that Lily, you are a groundbreaking thinker and advocate who has challenged me and broadened my thinking, and who always brings integrity and humanity to all of their work. So thank you so much, Juliana, for bringing us together. For those who I haven't had the pleasure of meeting yet, I'm a scholar of international criminal law, and as mentioned in the intro, I tend to look at gender-based crimes, including reproductive violence, sexual crimes, gender persecution, and others. So I've been looking at the International Criminal Court as my primary site, and then broadening that for the past decade and a half. My interest in the Rome Statute's definition of gender has never been in just gender in isolation, but it's what it does when coupled with the crime of persecution. What does gender, as defined in Article 7.3 of the Rome Statute, do when it is a ground of persecution? I strongly share the belief that there are better definitions of gender out there in the world, definitions that don't force gender diverse people throughout the world to define themselves by reference to a Western binary of male and female, or something in between. And I really want to amplify the call from one of India's leading scholars on gender and sexuality, Ahana Roy, who talks about the need to resist the forced mapping of global north gender and sexuality theorizations onto the global south. And I think that others in this call have been really articulate in their writing, and will be today, about why it's so important to have a broad and inclusive definition of gender. Having said all of that, I've also long been of the view that the Rome Statute's definition of gender, while not perfect and really quite 90s, it not only accommodates, but it requires interpreting gender as a social construct. And it requires that persecution on the grounds of gender, as defined in Article 7.3, must include persecution by reason of non-compliance with gender norms. And so that means gender persecution, as defined in the Rome Statute, has to include the targeting of women who rail against restrictions on our liberties. It has to include the targeting of LGBTQ+ people who are perceived as not complying with the persecutors' gender norms. And so, having looked very closely at both the Rome Statute and its negotiating history, but also in the way that it's being implemented, not just in ICC policies, but in actual investigations and charging, I've been very heartened to see that over the past decade and a bit, the International Criminal Court's prosecuting office has been taking a stance that gender, as defined in the Rome Statute, is socially constructed, that it does enable looking at persecution for those who deviate from strict gender norms, and that we are starting to see the chambers, that is the judges, accepting this broad and socially defined concept of gender in many situations, including in Mali, in Darfur, in Afghanistan, and others. So being very aware of that progress in the ICC's practice, it was initially quite a shock to me when I came to New York to observe the preliminary discussions in the Sixth Committee regarding the forthcoming Crimes Against Humanity Convention. And sitting there in UN headquarters in the Sixth Committee and hearing so many progressive states, including so many states parties to the ICC, who seemed hell-bent on rejecting the Rome Statute's definition of gender and characterising the Rome Statute's definition of gender as effectively equating gender with biological sex. So as I said, I was initially confused to see this dynamic. And since then, this confusion has turned or curdled into concern. If I could briefly sketch out my concerns, but I'd be very happy, and I'd actually relish the opportunity to tease them out with others on this call and explore these concerns. What we are seeing in the Sixth Committee and in the International Law Commission, and just more generally in the Crimes Against Humanity Convention process, when the term gender is discussed and its non-definition is discussed, I see a very broad-based support for an inclusive conception of gender. And I think that's very, very positive. I think it's entirely appropriate for a convention that is seeking to safeguard the rights and dignity of all people. And I think it's crucial to build on that momentum, both in the next stage of drafting the Crimes Against Humanity Convention and in international criminal law more broadly. Having said that, I see two risks with the way that this support for an inclusive definition or an inclusive conception of gender-based persecution has been expressed in the Crimes Against Humanity process thus far. So that is, I think the rationales that have been offered for dropping the Rome Statute's definition of gender raise some concerns. So the first risk that I see is that this broad criticism of the Rome Statute's definition of gender that has been voiced in New York might come back to bite at the ICC. Specifically, it might become harder for the ICC chambers to accept that violence directed at people because of their deviation from socially defined gender norms, including the worst kinds of persecution against LGBTQ+ people, it might become harder for the International Criminal Court to accept that that is gender persecution as defined in the Rome Statute if the travail préparatory for the Crimes Against Humanity Convention indicates the contrary. My second concern is about the implementation of a Crimes Against Humanity Convention at the national level, now that the term gender has been left undefined for good reasons, but I think they do raise concern as well. My concern here is that there's no clause currently in the Crimes Against Humanity Convention akin to Article 21.3 of the Rome Statute. And by that, I mean that in the draft articles on crimes against humanity, there is no provision that requires states to interpret the terms in the convention in accordance with international human rights law. As a result, there's nothing in the Crimes Against Humanity Convention so far that would stop conservative states from interpreting gender-based persecution to just mean persecution by reason of biological sex. And if they did that in their national jurisprudence, that would significantly blunt the power of the crime and strip it of a lot of its ambit. And I think that this risk is really quite concerning, because the countries in which gender-based persecution is the most acute and the most widespread are precisely the same states that are least likely to adopt a progressive definition of gender when implementing the Crimes Against Humanity Convention, unless there's a very strong push in that convention to do so. So that's why I have some concerns about the way that as Valerie has said, that the past is being brought into the present. I don't think it's too late to build on the momentum in the ICC and to come up with a better outcome in the Crimes Against Humanity Convention. I think that with negotiations for the Crimes Against Humanity Treaty on the horizon now, it is imperative that the opportunities be really understood, but also that the risks that I've alluded to be understood and ameliorated. And I think that states who are progressive and wanting to see a broad-based crime of gender persecution and their allies in civil society, when it comes to advocacy around the Crimes Against Humanity Convention, I think that there's a lot of scope to more consciously build on the developments that have been seen in international criminal court practice, and insisting on legal safeguards to mitigate the risks associated with leaving gender undefined in the Crimes Against Humanity Convention. And if we maybe try and steer that middle path, then I think that human rights advocates, gender justice advocates, and like-minded states will be really well equipped to strengthen legal protections against gender-based persecution in its myriad forms, both in the Rome Statute space, in the Crimes Against Humanity space, and in implementation domestically as well. But I think I'll stop there because I think others on this call have in the past challenged me to think differently, and I actually really would look forward to the opportunity to be challenged again today. So thank you.
Thank you so much. So now, going back to the in-person room, Lily, the floor is yours.
Thank you so much, Juliana, and thank you so much, Akila, Rose, Valerie. It's an honor to be in conversation with you today and going forward on this topic. I think we wouldn't be here today if it wasn't for the work of Valerie and others in this space. I was 10 years old in the mid-90s, so this is also an intergenerational and transgenerational conversation that I would like to
I was also 10 years old. Just kidding.
And in terms of my positionality, I define as a genderqueer non-binary person. I'm cognizant about the fact that I'm located in, but I'm also educated in the global minorities, the global north. It taught me a lot of things, but it taught me also that I have to unlearn a lot of things. Among them, the fact that gender is biological sex and/or binary construct. I studied international law, specialized in international criminal law, and I'm also a trained international crimes investigator. And I work one, among other things, as such. And maybe to also locate that my professional experience didn't start at the International Criminal Court. So while in my education, I studied the jurisprudence of the Yugoslav Tribunal, the Rwanda Tribunal, the Special Chambers for Cambodia, Special Chambers for Sierra Leone, and obviously the International Criminal Court. I practiced international law for the first time in domestic courts in Germany, as Juliana mentioned, where the investigation and prosecution of international crimes, particularly committed in Syria, but also Iraq, took place under the principle of universal jurisdiction, so that states have an obligation towards the Rome Statute system, but also international criminal law more broadly, to investigate and prosecute core international crimes if the state in which they are committed are unwilling or unable to do so. Some of my learnings that bring me also to this discussion here, one of which Juliana already mentioned, I think in the Al-Khatib trial that dealt with crimes committed against persons that were a real or perceived part of a political uprising in Syria as of March 2011, were arbitrarily detained and brought to Syrian government detention sites, where they experienced a range of violations, including sexual and gender-based crimes. And in the first case that went to trial internationally, which was the Al-Khatib case in Germany, sexual and gender-based crimes were the only category of crimes that were not charged as an international crime, and therefore stripped of their political but otherwise bigger structural mass violence context, namely that they occurred as part of a widespread and systematic attack against the civilian population in Syria. So these first experiences really taught me that although we have law, it's not always applied in a just way, and that we have to employ really intentionally strategies that changes that. And I think one of these strategies that I got really interested in was to really strengthen intersectionality as an applied approach in international justice work, and particularly in the investigation and prosecution, but also broader advocacy of international crimes. So maybe to give a concrete examples, I saw that people experience the multiplicity of harms, but also impact in the context of structural mass violence, and therefore also violations of international law, and that they may occur at the intersection of various grounds. So for example, Syrian women were targeted because of their real or perceived political activism, of course, because of their gender identity, because they were Syrian cisgender women, but also they experienced different treatment based on their religion and or whether they came from a particular urban space or rural space. And it was really at this intersection that the harm didn't really accurately got captured in the investigation, but also the legal characterization of the information that came out of the investigation. Another concrete example I can give, also from the German context, would be Yazidi boys, so cisgender boys under the age of 18, that were specifically targeted for slavery crimes, so the abduction, but also enslavement of them, and the way control was exercised over them was, among others, through torture, sexual violence, but also forced recruitment and forced fighting in armed forces. And it was really at the intersection of their ethnicity, their religion, their gender identity, but also their age. And it was at this background where I noticed these shortcomings that I really sought out the wisdom and learning of many people. Some of them are in this room, virtual room, but these would be persons such as Patricia Virsarcellis and her leading role in developing jurisprudence at the ICTY, ICTR, and later Special Advisor for Gender and Slavery Crimes at the International Criminal Court, but really also the writings of Diane Otto, Susanna Secuto, who has been mentioned, Leila Sadat, who also wrote about the difficulties and modes of liability, so the way you identify individual criminal responsibility for a particular person for substantive crime, and the way the modes of liability often applied in international law do not serve accountability for sexual and gender-based crimes and their structural dimension, including how gender discrimination drives it. Another person that really guided my work is Kirsten Campbell, Priya Gopalan, who have very different work in both activism but also practice. And that's also how I came across Juliana's work for the first time. And here I also want to mention the, I guess it's also a representational issue for me. So being a queer practitioner, I don't see a ton of other queer practitioners in the field that do this type of work. There are a few, but I think we can count them in maybe one, maybe two hands. The same, of course, when we talk about trans women, trans men, intersex persons, or indigenous persons, and many other persons with disabilities, many other positionality that are not part of the work and or the discussions we are having. And so that's a responsibility that I see upon myself, but also our different communities of practice in and outside the institution of changing that. I would also identify myself as a feminist. That's why I'm here. That is guided by the learnings of decoloniality and anti-coloniality, and really the understanding that gender in and of itself has been a way to subalternize persons by controlling their gender identity, by controlling their relationships, by controlling their land, their resources, the way they are governed, the way they are educated or have access thereto. And so in my unlearning and learning about gender, authors like Sylvia Tamal or Maria Lugones, that we also refer to in our writing with Juliana, that really see gender itself as a colonial introduction, as a way to subalternize and dominate persons. And that's really something we have to understand when we look at why are persons targeted because of their gender identity, because of their gender expression and or their sexualities. I think what's really interesting about the draft articles on prevention and punishment of crimes against humanity is that there is a shift in where, how, and by whom international law is being made. So there is a shift in different states, particularly from the global majority, taking a bit more center stage, such as, for example, Sierra Leone, who wasn't super present during the Rome Statute negotiation. And I think this shift is really interesting for gender, but also for potentially other substantive changes, such as the international crimes of the slave trade. I think it's also up for discussion to reflect again on colonialism as a crime against humanity, land exploitation, and resource exploitation. So these are all not crimes that we can find in the Rome Statute, and there's a reason for it that maybe it has now a second chance of revival. So how does any of what I just said relates to the discussion today? So Article 7.3, we already heard so much about it, two sexes within the context of the society. To start with the more positive note, I'm really a big proponent and a fan of the phrase within the context of society. I think it's really an impetus for those that investigate, analyze, and prosecute international crimes to be guided by the lived experiences, the history, really persons with lived experience from the context in which we as outsiders often, more often than not, seek to understand harm and their impacts over time. But I would also love to clear this discussion a little bit by moving us beyond the discussion, is it biological sex or gender as a social construct? So if I look at the jurisprudence, international criminal law jurisprudence, and also the OTP policy paper, I refer specifically to the 2022 gender persecution policy paper, and then also, as mentioned, the 2023 updated gender-based crimes policy paper. What I can really put my signature on is to say, yes, of course, at Rome, there was an attempt, which I'm immensely grateful for, and the labor of which I deeply honor, because without that, we wouldn't be having any of these discussions. And without that, we wouldn't have any of the jurisprudential advances that we do have today, and also conceptual advances to enshrine gender as a social construct in the Rome Statute. But I do believe what we have is imperfect, because in the most generous way, I could support, yes, we have gender as a social construct, but really in a very binary way that, if at all, applies to cisgender persons. Why am I saying that? Because we have Article 7.3, it says two sexes, male and female, in the context of society. We have the gender persecution policy and the gender-based crimes policy that maintain maleness and femaleness as quote unquote goalposts, and I quote Juliana and myself here, to understand gender in the context of the society. And male and femaleness are markers of biological sex. So I think both the gender persecution policy and the gender-based crimes policy could have been an opening to introduce feminine presenting or masculine presenting, or in general, femininity and masculinity as much more progressive, but also queer lenses to understand gender identity, expression, and sexualities. And then, yes, we have Article 21.3, which we are going to talk about today, which essentially asks the court to interpret and apply international criminal law, the Rome Statute, in accordance with international law, to be non-discriminatory. But also it's an invitation and really a responsibility to look at international human rights laws already mentioned. I'm sure we're going to go further into it. But I think Article 21.3 is a little bit of the key and the pathway we should be taking, but not just to say gender is a social construct. I think international human rights law, and I can go further into this later, really in 2025 promotes a non-binary approach to gender. And Akila and I, more Akila than I, Akila really took the leadership in 2023 to lead a huge feminist coalition CSO effort to propose substantive correction and addition to the draft articles on crimes against humanity, including forced marriage, including the slave trade, including gender apartheid. But these briefs were submitted to states with a cover letter. And in that cover letter, we were really adamant about the fact that principles of non-discrimination and a clause akin to Article 21.3 also have to be included in the draft articles on crimes against humanity, among others also because it will aid and support and mitigate the risks that come with a non-definition of gender. And maybe I'll leave it here for the moment.
Okay, thank you so much, Lily. And now I turn to Akila, please.
Thank you so much, Juliana. Thank you for really bringing so many of my favorite people to work with and strategize with and conspire with together into a conversation. I think that to me, in doing this work, the amount that I learn from my colleagues in both when we're working kind of in clarity with a very similar approach and sometimes in challenge, it's really where I think we all sharpen and improve. So I'm just really grateful for the convening of the conversation and for the spirit with which everybody is engaging here, because I think that it's really how we improve and get better in this moment. So kind of to where I came to this work. So a lot of the focus of my work as someone who kind of straddles a couple different areas has really been to try to build and develop feminist and progressive interpretations and jurisprudence of international law. And a lot of my early career was spent on issues of reproductive rights, particularly abortion access. And that I think was actually perhaps some of the best boot camp that I could have to walk into the challenge of what it looks like now to be dealing with issues of gender in an environment where it's actually not 1998. In a certain way, 1998 was a more open environment for progress on gender, and the way we've seen certain shifts with states and other pieces of the environment, we really need to be in a place right now to think about how do we not just preserve what we have, but actually move forward. How do we build? How do we progress? Because we lose if all we're engaged in doing in this work of feminist advocacy is maintaining the status quo, right? And so the work on abortion, where everyone constantly accuses you of destroying something, ruining rights, ruining processes, ruining a text by trying to get something about abortion in there, was just, some of the best boot camp for me in terms of really learning about how do you try to walk in with clarity about how you continue to progress and push forward. And so, really to me, that was such an important part of thinking about things like how do we conceptualize gender more broadly, because the minute you raise the issue, all you're met with is challenge, right? That outside of a room like this, where we're all trying to think constructively, when you try to raise this with states, when you try to bring this up in, non kind of same-minded spaces, all you get are a list of why it's not possible, why, et cetera, et cetera, et cetera. So that's really, I think, to me, a lot of what I've been thinking about as we come into this conversation. And so, I've done work on developing, trying to get abortion access thought of as something that's a rights entitlement under international humanitarian law, really met with a lot of resistance, not just, and I think what I want to say here, one thing I want to say here is the resistance that I've often met in some of the work that I've done, and I think we see this a lot, is the resistance often, the first line of resistance isn't from those you think are your enemies or who you're trying to shift or change. It often comes from those within your own community, right? And so when I was doing the work on abortion in IHL, a lot of the challenges, and actually in some ways, those who tried to thwart the work because they hadn't thought of it, they didn't like the argument, whatever it was, actually came from within the community that I was working in, because it was novel, it was pushing it forward. And so, when you're engaging in this, and I don't want to call it a battle, but sometimes that's what it feels like, you're often having to work not just in terms of, shifting the people out there who you think don't care about the issues that you're talking about, but the people from within your own community. And some of that, I think, also is that we're pushed into such a, small piece of this world where it sometimes feels like what we're doing is fighting for the same piece of the pie rather than thinking about how we expand it. So those are all the things that, have kind of brought me to this conversation. And then maybe just a bit more concretely to situate where we're at as it relates very specifically to the Crimes Against Humanity Treaty. So as Lily mentioned, this is work that I've been engaged in for a while. I've been engaged with it since it was actually with the International Law Commission. And we did I was at the Global Justice Center at the time as the legal director, and then subsequently as the president. And there we really started engaging with the process to think about what it would mean to bring a gender perspective, a gender competent perspective to the entirety of the treaty. And so back in 2018, when we first started really engaging with it, we were looking at two things. One was really engaging with this coalition effort that has been described by both Valerie and Rose, and really thinking about how gender is defined or not defined in the treaty, that led to the ILC's decision to not include a definition of gender. And we were also trying to push for some of the other issues, including the definition of forced pregnancy, which was copied over from the Rome Statute, which we thought had some problematic provisions attached to it. And then since about 2020, I started engaging really with the political process of the Crimes Against Humanity Treaty, really looking at what it would take to move the treaty from something that was stuck in a UN committee to negotiations, working with really an incredible group of scholars and advocates and activists. But the one I would be remiss if I didn't name is Layla Sadat, who has been the backbone of trying to get a standalone treaty on crimes against humanity, who really, I think, deserves so much credit for all that she has done to get us to where we're at now, which is on the precipice of actually being able to negotiate and do something about this question, which could have just been academic if it wasn't for also the important engagement in the political process to actually get it over the finish line. And so as we were engaging in the political conversation, it became apparent that there were going to be moments where we could actually start to bring back the discussions on some of the substantive issues, particularly the gender issues. And in the work that we were doing, and really thankful so much to the incredible community of folks who are, the Lily, Valerie, and Rose who are in this conversation, but so many others who I know are on the online space and in the room today, who gave their time, their energy, their thinking to what would it mean if, instead of coming to the conversation at the end, which is often where gender considerations come in, we came in early. And we came in kind of at different parts of this process before we were even at negotiations. And much like many other things that I've done in my career, we were accused of the fact that this work would tank the process, that it was too early, that why are you starting to raise these issues now? You really could disrupt the conversation. And I'm really, happy to report that we did not, in fact, disrupt it. And in my view, the work that was done by the group of feminists, the work that Lily was describing, actually helped to strengthen the process. It helped to strengthen the interest. It helped to get more engagement about what are the possibilities of a treaty like this, right? Because if we're going to negotiate a treaty in 2025, it shouldn't just be what was in 1998 that we can hope to carry forward. We need to think about the future. We need to think about what a treaty in 2025 means when it comes to issues of gender competency, what it means to come to issues of feminism. And so we did some early work around getting briefs and written submissions over to states, engaging in regularized advocacy with states in New York to really get them to start thinking about how can they raise gender issues as this process was ongoing even before it was at negotiations. And so as a result, as we walk into negotiations, we actually have a really solid baseline to work on, including on the issue of the definition of gender. And so we have had states expressly support the codification of particular crimes, right? In a way, the way that I think about it is like a three-part narrative. So in terms of what we initially proposed, right, we were looking sometimes at what it would mean to fix what was in international law in the moment. So in the context of the definition of forced pregnancy, looking at dropping the caveat on national laws. But not only that, actually, as it relates to this conversation on thinking expansively on gender, also a proposal on how to make the language of that crime inclusive, because right now it's defined only as women. And so putting forward a proposal that actually said that forced pregnancy should be defined as noting women, girls, and other people who have the capacity to become pregnant, including the overlooked fact of the lack of inclusion in the slave trade. We also looked at how it is that the current Crimes Against Humanity Treaty can catch up to some of the jurisprudence that we've seen develop in other courts and at the ICC itself. So issues of forced marriage, which Valerie has been really the leader on, and looking at the concepts of reproductive violence that have been developing in Latin America, in domestic courts and regional courts. And Rose has been such an incredible thought leader on those issues and really thinking about how we incorporate that. And then new issues like the emerging concept of gender apartheid and really how we bring it in. And so, all of this was conceptualized with some concrete ideas, but with the idea that what we're really going for is a gender competent approach. And I'll conclude by maybe just saying what I think we've accomplished so far and maybe where that leaves us as we go into the next stage of this discussion. So we do actually have, and this is from some of the final reports of the discussions in the UN 6th Committee on the Treaty. So we actually, Lily mentioned that one of the overarching things we called for was a non-discrimination provision language that's like Article 21.3. And we actually saw that states did in fact propose including a gender perspective in the preambular paragraphs of the treaty, and in addition proposed adding references to human rights in the preambular paragraph. So as we think about 21.3, we have a little bit of a baseline to think about how it is that maybe we can build on that. In addition, we have seen quite a few states be very supportive of the fact that gender should remain undefined in the treaty. We have also seen pushback from states who want to put back the Rome Statute definition, because I think that there is a belief, and Rose, I really love the perspectives that you have on this and really thinking about where that belief is coming from, that it is in fact this binary definition. The other piece of opening that I've seen there is that for states who are sitting in the middle or even in one of these positions, there has also been a call to help, if there's a definition or if there's not a definition, the need for some sort of way to clarify what this means, right? How it is that we're supposed to interpret it. And I think it hasn't been raised yet, but the fact of the matter is as it relates to the treaty, none of the other grounds for persecution, including race, religion, and ethnicity, are actually defined in the treaty. Gender is the only ground that is defined in the treaty. And so, I think that where we're at now is we move towards negotiations with amendment proposals potentially in 2026 and negotiations in 2028 and 2029. We have the opportunity for us to really sit down and think about how do we approach this conversation? How do we push for, I think, what we are all in agreement on in terms of the reason we came to this conversation, an approach to gender in the Crimes Against Humanity Treaty that is as inclusive and as progressive as possible, and one that I think thinks about how, if we depart from something like the Rome Statute, which is something we're calling for as it relates to other crimes as well, how do we make sure that we protect and secure the jurisprudence, the work that's already been done in these institutions, and allows an institution like the ICC to continue to push forward, and at the same time perhaps not be stuck to what was a compromise or a negotiation in the past. So I'll stop here.
Thank you so much, Akila, for these wonderful comments. I think what we could do right now, if if you all allow me, because I really want to have the participation from people in the room and also from people in the virtual room. But before that, I just wanted to give a little bit of like a thought exercise for all of us. Because of course, like I was taking notes, and what we discussed in the emails, back and forth emails, is like, of course, like we have several different perspectives and approaches to addressing like how we think that the negotiations about gender should be conducted. But and this is, of course, like something that I think boggles the mind of all feminists, and especially like when Akila was talking about how sometimes contestation and resistance comes from our own very heated debates with our colleagues, and we're like, no. But I think it's just like, especially like thinking about coalitions between different feminisms, and what in your work, specifically in this area, has worked. Because I don't know if you know, but this event, it was basically me trying to conspire with people on how, which kind of like strategies could actually work in bringing together different feminists, so we could actually have something like strategic and clear to put forward for these negotiations. So from your different perspectives and experiences, which have been the strategies of coalitions that have worked with the different negotiators in this process? Because it's not just like the feminists talking together, we're also talking to states and other NGOs. So two questions: which kind of strategies for coalition amongst ourselves have worked in that area? And which kind of strategies would you like to see? Right? I think feminism also has like a little bit of like that imaginary hopeful. Also, I think about Otto and like the hope and despair that she always talks about in feminist work. So a little bit of like the hope and despair that has like triggered you, and just like, okay, this is what we can do, and this is what I would like to do in the area. So strategies for coalition. Now, we're just going to follow the same order. So Valerie, then Rose, and then Lily and Akila. Okay, Valerie, please.
Right. So within feminist movements, one approach that I find is really helpful is when we are all together thinking about how all crimes are gendered in some way, shape, or form. And outside of the feminist communities, sometimes that statement is shocking, you know, when if people are not, if they don't have their head in this space, what do you mean all crimes are gendered? Most crimes are gender neutral except for the gendered crimes. It's like, no, actually, well, in my point of view, many people's point of view who speak about this all the time, all crimes are gendered in some way, shape, or form. It could be that they are gendered in the way the targeting happens, or it could be that it is in the way in which the effects are felt, but all crimes are gendered. So I think that's helpful within the communities to think about that. And also, it's been fantastic being a part of this community that we have gathered here today, but also it's a much larger community, to think about how to tease apart different aspects of what we are talking about that often get lumped together. So for example, what are sexual violence crimes? How are those perceived differently from culture to culture, society to society, person to person? How are reproductive violence crimes? First of all, what are they, and how are they different? Or how might they be different from place to place? What are relational autonomy crimes? This is an area that I think a lot about, like forced marriage. What does that mean in international criminal law? And what are other types of gendered crimes that are either not yet named or that need better naming or labeling in order to be recognized as gendered crimes? So I find all of this internal discussion helpful. Externally, strategically and pragmatically, I find it helpful to discuss with countries, for example, what is gender persecution? And what are the constellation of human rights violations? And under the Rome Statute definition, coupled with international crimes, genocide, war crimes and crimes against humanity, that when you bring all of that together, it amounts to gender-based persecution or forms of gender persecution. I find that thought process really helpful because it's something that those who are not always thinking about what the conceptualization of gender is, I think it helps them to get their head around what we're talking about when we're talking about a gendered crime that is not necessarily a sexual violence crime.
Okay, great. So Rose, please, your thoughts on strategies for coalition.
My thoughts on strategies for coalition is that I love working in coalition with others. I much prefer that to working in silos. And I've had just the most productive experiences, for example, with people in this call. In terms of working in coalition within other feminist circles, broadly defined, I really think a humility and an openness to seeing it from somebody else's perspective helps me, because often I have built a very intricate argument in my mind and it is really important to listen and not be immediately refuting in one's mind what somebody else is saying, but really be open to having your mind changed. I think that has benefited me a lot, and I think it's always a good thing to do, is to think about listening very carefully and being open to change. In terms of strategies within kind of our gender circles, I also think it's very important to have conversations across different jurisdictions, because I, for example, am well versed in international criminal court, but I can learn a lot, say, from Lily's work talking about German cases, including German gender persecution cases. In the reproductive violence space, I find it very informative to look, for example, at Colombia and the HEP and other jurisdictions. My point here is that there's often a lot going on, whether it's in terms of reproductive violence or gender crimes generally, outside of the Hague or New York or Geneva. And I think it's very important to then build coalitions that allow us to access that other learning and information, so that we are working with awareness of developments that are happening in other spaces, and so that we are consciously building on and not inadvertently undercutting progress that has been made elsewhere. And I do see, as I mentioned, a risk of some undercutting of work that's been done in the ICC, for example, but I think likewise this is a risk that could transpire in all different spaces of lawmaking and law implementing, if we're not having coalitions that can keep us abreast of what's happening in other jurisdictions. A strategy that I find a useful one to think about, and I'd love to hear everyone, especially Professor Oosterveld, talk to, is constructive ambiguity in treaty making, because Valerie has written wonderfully about how this term, within the context of society, in the definition of gender that the ICC has, is there because it was a way to overcome a negotiating impasse between some states who were adamant that gender had to only mean sex or only biological binary sex, and the larger cohort of progressive states, including Canada and others, who understood gender in much more inclusive and socially defined terms. And so the way to do that was to have a phrase that it opened the door to thinking about social constructs while leaving enough unsaid that it was able to be negotiated, and leaving it for the court to fill in the gaps. And like Lily, I'm a very big fan of that clause, and I am very indebted to Valerie and others for ensuring that it was there. So I think what can we learn from that going forward is that where else might a little bit of ambiguity be constructive for us? One place I see it, for example, in the Crimes Against Humanity Treaty is, together with Aquila and others on this call, I think crime against humanity of just reproductive violence, broadly defined, would be a good example of constructive ambiguity, because there was a lot that could be done with that, but hopefully it doesn't scare the horses too much in the way that it might if we sort of said like, this is a publicly broaded call. But you know, I think it's a good place to leave some openness for interpretation. So that's one for us to think about as well. And even constructive silences, which is something that Lily and Juliana and others have written about. One thing I'm not sure about, and I think this comes back to what Akila is talking about, is where is it worth trying to be a pragmatist and making compromises with states that are not like-minded, and where is it just not worth it? Where does it become unprincipled? And it would be a better idea to just not water down a provision, to not give way in order to placate some states that, let's be honest, let's real talk, are going to keep committing the types of crimes we're worried about anyway. I think this is an important consideration for all kinds of openings, whether it's reproductive violence, gender apartheid, gender persecution, or others. Are there lessons to be drawn from the past about where perhaps there was a compromise that wasn't worth it? Something for us to think about. I don't know the answer to that, but I think there are others who are wiser on this call who might be able to speak to that.
Thank you. So Lily, on to you.
Okay, so I think maybe to be a little bit less diplomatic than my first round and also to be very clear, like, I think we have to do, so first of all, I'm not convinced that the definition we have right now, two sexes within the context of society, the two sexes being male and female, legally protect intersex people without a nuanced understanding, legal argument, or justification how you come to that conclusion. And no one has provided that publicly in any sort of guidance document from the OTP. I also don't think we have any evidence that trans people or trans kids are being protected and are within the eyesight of the international criminal justice system. I think I noticed in the application for arrest against the Supreme Leader and the Chief Justice of the Taliban, which, yes, I agree, it's a milestone. It's amazing to know the International Criminal Court is looking into this. There's progress in the work. And there are many progressive aspects to the applications for arrest that have been publicly pointed out. However, girls in paragraph 41 of the applications for arrest are defined as female children. And this, by its own wording, excludes anyone under the definition of a girl that's not a female child. So please explain to me then how we have a social construct in relation to children. I think also another thing where we have to really be a bit more nuanced about the wording that we use and the result this will have for legal protection of people is if we use the phrase members of the LGBTQA+ community. So I'm not a member of any singular community. I think within that umbrella, we run risk of really conflating sexuality and gender identity and gender expression and sex characteristics, where I think we have a much more nuanced wording, including from queer scholarship, including from international human rights law, that it doesn't serve us if we say members of the LGBTQA+ community. We are demographic, we're not a singular community. And even within that idea of community, there may be right-wing people. I'm quoting this from my own partner who I've discussed it with extensively. So I think what I hope for is really a coalition that in a queer way can say something is not working. And for now, we don't have the answer, but we are committed as feminists to finding it together. And at the same time, we are not clueless. There are clues, there are guidance, including in international human rights law and other sources of international law. Also, customary international law, gender-based violence, has been recognized as customary international law. And how do we make sure it protects the people it's meant to be protecting? And I think there's really where, for me, the hope lies. So I think in terms of coalition building, what has worked for me are some of the initiatives that we have discussed, but really to not see states as our possibilities, but to see the real life impacts of violence as where we have to go. And I think that's our job as people who don't work as representatives of governments, to really advance protection for those people where in jurisprudence we simply haven't seen it. I think evident of this is also that in Germany, sexual orientation in June 2024 was added as a ground of persecution next to gender. I'm not saying by any means that this is in any way perfect, but it shows there are strategies outside, and this is maybe not the right one, but there are ways. It can be legal reform, but it can also be very concrete feminist advocacy of providing states with a memo on, in 2025, what does international human rights law say on what gender is? And to provide legal advisors with guidance and ongoing discussion, in as much as we've done it with other issues, in as much as we've done it with, Akila has led the work on gender apartheid, Valerie has led the work on forced marriage, Patricia Versailles has led the work on the slave trade. Rose has led the work on reproductive violence. We have a blueprint of explaining the unfamiliar to the advocates that can enact the change. So why can we not do it in a similar way? I think in a reality in which there's already a deletion of the gender definition, and where we also have United Nations independent experts in 2018 or 19 saying that this definition should be deleted, and it has been, to go back now and say what we have at the Rome Statute is working because we have two policies that are more progressive, is to me a bigger risk than engaging from a different viewpoint that takes the Rome Statute and the guidance there, and we honor it, but we really build upon that as well. And also to bring in queerness in here, it doesn't have to be one or the others. It can be a combination. And to finish, coalition building also, I think, requires us to have, the learnings of Indigenous people. We talked a lot about time, past, present, and future. I think in the Indigenous idea of time or the Indigenous idea of land, it doesn't work like that. So how do we incorporate in our understanding of how we understand gender and its context, really perspectives within our coalitions while we prepare these memos, while we prepare the writings, but how do we incorporate different forms of knowledges so that all people feel kind of represented in our quest to maximize legal protection?
Thank you. So now, Akila, you have the floor.
Thank you. It's hard to go after three people who have such incredible thinking on this. So I'm gonna, instead of repeating, maybe I'll draw a little bit from what folks have said. So I think in terms of, and I've spent a lot of my time as someone who has been in the NGO world working in coalition, or trying to work in coalition with, different layers of success, right? And I think the first thing that comes to mind that I think that this conversation is already kind of breaking the pattern of is that oftentimes in strategy, we try to eliminate complexity rather than invite complexity. Because I think that we fear that the more things you bring in, the more impossible the task becomes. And I actually think that there's a need to maybe shift the thinking and the framework, that the complexity sharpens us. Right? So much of maybe what has been left out, who has been left out, has been through a sort of pragmatic approach of saying, well, this is a conversation that's really just for lawyers. you need to have expertise in X, Y, and Z to participate and for the views that are articulated to be relevant, so that we can move forward, right? And I think that that's what's maybe gotten us to a place where we're not exactly where we want to be, and this work is incredibly iterative. And what we do now in 2025 and whatever product we get in 2029 is probably going to be viewed as outdated by somebody in 2050 and in 2060, right? We're all learning in this space. And so I think that the first thing that I think about is, how do we continue to invite complexity, invite challenge, and build that into how we work in coalition and strategize and approach these issues, rather than try to make things narrower and narrower. And so really, again, I think this conversation is allowing us to do exactly that. And in a way that I really deeply appreciate the fact that, complexity and challenge does not need to be negative. It doesn't need to be associated with negative emotions or fear. And in fact, I think it's important that we start thinking about how we bring these issues into the conversation, and we view them as positive, and we view them as something that helps shift, change, and sharpen each and every one of us as a member of this community who, again, we all share the same goal. And so I think that's one thing for me. There's two other things I'll try to be brief on. The other thing that, and I've seen that play out already in this crimes against humanity process, is oftentimes when we're thinking about strategy, when we're thinking about what we do, where we start matters. And often where we start is with the question of what is possible. We become states. We go, okay, we're only going to be able to get 3 things. So let's figure out what those 3 things are right at the beginning and only approach those. And I think that when we have these conversations, to the extent that it's possible, we need to start talking about, what do we need? What do we want? How do we make this a bigger space to bring all of those issues together? Yes, and I'm a relentless optimist. And I think sometimes to some folks that comes off as naive, but I think that the accomplishments that we've been able to show that it's not naivety, but rather just trying to think a little bit differently, right? So how do we say, in this process on crimes against humanity, we've already got some great ideas on the table that have had uptake from states. Do we say, okay, mission accomplished, that's all we do? Because we've only, we really had that work was done in an incredible manner in a very short period of time, through the generosity of voluntary time of those who were already engaged with the process and had the capacity to participate. So what does it mean for us to then think about, as we move forward, adding to the asks? It's been said to me many times, there's a lot of things on gender. What are your top picks? Because the idea is we can have a list of 15 things on jurisdiction, on immunities, on all of these different issues, but gender, you get like 1 or 2. And the expectation is that we narrow from what we already have. And to me, with 4 years to go, we add more, and we think about how we expand. And we, at the end of the day, what we may get is not everything that we ask for, but we tell the narrative, we build the story, right? We say what we want. We help to lay the groundwork for what we're able to accomplish. We tell our part of the story. And we also then create the pathway to continue to build this after something that is a singular treaty negotiation. This is a really important opportunity, but we cannot think of it as the only opportunity. So if we do the work now to really think a little bit bigger, we can do what all of us, I think, have benefited on in this feminist community, is building on the ideas and the proposals of those who came before us. Not everything that was accomplished in the way it got into a treaty or the way it got into jurisprudence that's perfect, but how we actually continue to learn and shift and build from that. And the last thing, again, is I think rejecting the pressures of time. The other thing I often see is that we feel very pressure to say, oh, we have to get this done in 3 months. Therefore, this is all we have the capacity or ability to do. And of course, capacity and resources are very real constraints. But again, how do we try ourselves to push in every turn and say, okay, we have 3 months. This is what we can do now, but how do we build towards what we do in the next 3 months and the next 3 months after that? So that again, what doesn't happen through these constraints that are imposed on us externally is the exclusion of those who have really valuable perspectives to share that are maybe they don't have the capacity or the resources to participate immediately in the first iteration, or that they're not, that it's not the folks who we see as having the relevant expertise, and there's work that needs to be done to understand, develop, translate what we're talking about in law down to, victims and survivors, translate what victims and survivors and those with lived experiences are seeing as valuable, important, and needed into how we engage in legal advocacy and strategy. And so those are the things that I think I'm really sitting with, and they really resonate with everything that Rose and Valerie and Lily have said, because yes, there are very practical things we want to accomplish, but I think that what I've learned from the work of feminist collectives and strategizing is that if we just narrow everything down into one decision, one opportunity, we're never actually going to get to what we want. And so we need to be thinking about what we want, just not out of something in 2029, but also what we want that goes forward into 2030, 2040.
Okay, thank you so much. Now, finally, people from the audience, either online or in person, any burning questions, comments? The floor is yours. So just raise your hand and we'll be happy to answer. I'm also tracking everyone online. You can just type your questions in the Q&A and we will be answering some of them. So yes, people, I'm going to be that person, but I'm going to give a little bit of a preference for the people in the room first, and then we're going to the virtual room. So people in the room, come on, people, ask questions. Go. Yes, please.
Hi, my name is Vinicius. I'm a first-year PhD here, and I'm studying the protection of LGBTI persons in war, armed conflicts. And my question is to you, Lily, because the persecution is not a standalone crime. And last week, the OTP said that LGBTI should be protected because they are gender perceived as targeted persons. So can we protect trans and intersex persons also by that gender perceivement notion? And if I personally don't agree, I would like to know your opinion. And because that's the construction we have been making, that LGBTI should be protected under the lenses of gender. And second, a second question is, why are we not focusing in LGBTI protection under the universal protection of human rights that's in the Rome Statute 21? Because we are focusing on persecution, but it's not standalone crime because we have to also to prove another crime against humanity. So why are we not trying to protect LGBTIs as a universal recognition in human rights?
Good question. Obviously, all others can come in. So yeah, I also have some questions on the applications for arrest. Some of them are already mentioned. I think one of my question also would be that, and it's also discussed in the applications for arrest, that persecution on gender ground is the one and only count in the applications for arrest, yet international criminal law usually requires a connection crime, none of which, not even other inhumane acts, is charged. But maybe that's a separate conversation to your question. I just put a question mark behind that. So yeah, I was also a little bit surprised to see that argumentation, which is also why I propose now that I think we have to be a bit more nuanced going forward. I think for me, it was also interesting that the applications argued the person were targeted because of their deviation from the gender ideology. I would argue that it is the gender ideology of the Taliban to persecute persons of sexualities and gender identities and expressions that are non-heterosexual and that are non-cisgender. And I think, yeah, we have to be a bit more nuanced in this way, but I think, and we discussed this with Juliana and others as well, I think what we see in the legal argument and also in the gender analysis of the applications for arrest is really a grappling with two sexes, male and female, in the context of the society that's meant to protect queer, intersex, and trans persons, and then with reference to maybe the two policy documents. But there is no factual, evidentiary, or otherwise analytical legal argument made as to how intersex people are connected. It's in paragraph 90 where it says queer, intersex, and I think non-binary persons experience these violations, and therefore they are protected, under this argument we are constructing. And I think we have to deconflate, and Juliana wrote about this more than I have, and we wrote about it together, to look really through the lens of sexuality, through the lens of gender identity, through the lens of sexual characteristics in and of itself, but then also in an intersecting way to these different, violations as to why people are harmed by whom and with what consequences. And the consequences being harmed on the grounds of your gender identity or expression may be significantly different, or they may be worse because you're also targeted because of your sexual orientation or because of your ethnicity or your age. So I think it's really intersectionality can be one lens, but I think really this deconflation of sexual orientation and gender identity and expression on the other hand as well. So maybe I'll leave it there, but I know Valerie probably has things to add.
I only have two thoughts to add, which are that in the Rome Statute, persecution is committed in connection with other crimes, but it doesn't mean that other crimes need to be charged. So long as the connection is demonstrated, there need not be another charge that needs to be proven beyond a reasonable doubt in order for the persecution charge to stand. So I think that is the thinking behind, and I'm speaking in my academic capacity. I think that's the thinking behind the way in which the charge was made. And I'll just add an observation, perhaps, and I don't know exactly where this sits because it's one that I grapple with also, and I don't know if the others grapple with it too. But when you're thinking of the crime of gender persecution, the way in which it's demonstrated is through the eyes of the perpetrator, right? Through the intent of the perpetrator, through the mens rea of the perpetrator. And very often in conflicts and mass atrocity situations around the world, the perpetrator is trying to force somebody into a sex binary box. And the nuances that we are having in our discussion of what gender means and can mean is not part of the perpetrators plural points of view, or at least it's not articulated necessarily in that way. So then there's a dissonance between the way in which the term is approached, I guess, even within the crime itself. And I don't quite know where to put that, but it is something that I keep in mind as I'm kind of flipping back and forth between what are the perpetrator's intentions or motives, and then what does gender mean conceptually in international criminal law and international law more generally. Can I just throw in something that I really like Lily's idea of having some kind of brief in the Crimes Against Humanity Convention discussions about what gender is and means in 2025, 2026, whenever it is that this would come out, because I think this could be very good for the criminal repertoire, and it could be very good for getting states to think about this. And I also take up Akila's point of view. We need to bring in complexity because multilateral negotiations squash down the issues and take out that complexity when the pressure is on. And the better starting place that we are at, the better the treaty will end up in terms of being gender competent.
So I see that Rose has her hand up online, so go Rose.
I'm going to take up this invitation to invite in complexity. And I want to speak to this really important question that's been raised about how does acts targeting people because of their sex characteristics, that they're intersex, or I'm going to also put in the mix because they are neither male or female identifying. There might be binary, there might be, in my regions of the world, we have all different words, fafafana, fetibai, all these different ways that people can identify. When I started my remarks at the beginning of today, I mentioned that my interest in the Rome Statute's definition of gender has not really been just on the definition as contained in Article 7.3 by itself, but what it does when it's coupled with persecution, what it does when gender is a grounds of persecution. And I want to come back to that in relation to this point. The reason that religious zealots or other very, I'm searching for words, Taliban-esque or other radicals target people because they are not cisgender or because they are intersex or because they don't present as male enough or female enough or anything like that, is because they are pathologizing things that should not be pathologized. It's entirely natural and wonderful that humanity comes in all different shapes and forms and that not everybody is exclusively male or female, either in their bodies or in their identity. That is a richness that makes humanity brighter, and it's a, those who come from a more progressive point of view would embrace and be enriched by that diversity, as opposed to persecutors who would want to quash it and pathologize it. But what I'm saying here is that the reason I think that a person who has intersex body characteristics or a person that is non-binary would be targeted is precisely because of gender. It is precisely because the persecutors have in their mind the two sexes in the context of society. In the persecutor's mind, that means that those two categories, those two named categories of male and female, should predetermine and should exhaust the way that humanity presents. That is a social construct. That is not a biological fact. It is the social construct and the prejudice that they are bringing to it. I'm sure there are more elegant ways of phrasing this, and I think I'd be delighted to be working with others to kind of fine-tune the messaging here. What I'm trying to say is I think it is definitely because of an ideal, the persecutor's ideal of that there are two sexes, and in their society, that means they are the only two types. They should exhaust the two types that are out there. Everyone should fit neatly into one or either of these boxes. I see that as a gender ideology that underpins targeting not just of women and not just of people who are homosexual, but also people who are intersex, also people who are non-binary or gender fluid as well. So I think that if we could find a way to explain that complexity, I think that there is a really strong basis in what the ICC is already doing in its policies and practice to support this argument. And then I'm not saying at all that in the crimes against humanity space, that the call should be to go back to the Rome Statute's definition. I think that ship has sailed, but rather I think it should be to interpret gender in light of international human rights law and in light of ICC jurisprudence and in light of the Rome Statute's definition. And I think all of these different bodies of law point us to a direction that would be inclusive in the terms that we're seeing. And yeah, that's where I'd like to go with that one.
Okay, thank you so much. Akila, do you want to add to the question or should I? Okay,
Can I say
Yes.
Just on this, I think there's also a point to be made that gender persecution or persecution on gender grounds is not the only crime to hold individuals individually criminally accountable for crimes committed against non-heterosexual, non-cisgender persons. And I know it's not a requirement under the Rome Statute, but I also think there are decades of legal and prosecutorial and investigative strategies of cumulative charging because we need safety nets. And I really look forward to the additional arrest applications for arrest warrants, which hopefully bring that.
Okay,
I wanted to add that.
thank you. Certainly it's dark in the room, and I'm just like, what's happening? It adds a little bit of drama, right? Okay, so we have questions popping in. So just so you know, we're going to finish at 12, if that's all right with everyone. All right, so I am going to, I have a few questions from the online audience, and there's one from Jessica Benton. Hi, Jessica. So I'd like to ask the speakers thoughts on whether they feel the long-standing absence of disability and any attention on disability-based crimes like mass deprivation of liberty and torture hinders intersectional justice, especially for women and girls with disabilities. That's a very interesting question. Thank you, Jessica. What do you think about it? Let's go.
Well, we should absolutely have a disability, and I suspect that there's agreement amongst all of us.
That was very quick.
Yes.
Yes, so the answer, yes. Again, light. So there's light again. So with this a very amazing answer, there's light again in the room. Okay, Akila wants to speak. Yes, please.
I dropped a link in the chat, but I just want to highlight there's some really amazing thinking and work that's already going on as it relates to the Crimes Against Humanity Convention and issues of disability that is being led out of Janet Lord, and others have been engaged in this process actually for a couple of years now. Because I think that as the question is identified, there is rightly a gap kind of in some of the intersections that we think about. And so there is really important work. And I think that on our end, in the work that we're doing on gender, there's definitely an important need to bring the work that they're doing more generally across different issues of disability into the gender related work that we're doing. But if you're interested, I put a link in the chat, and very happy if you want to follow up. I'm happy to link you up with those who are doing that work, because I think that it's incredibly important. And I think that the other thing you're highlighting is, you know, how is it that we use 2025 to expand our notions of who should be at the table, what issues should be at the table, and how we make sure that we take an inclusive approach to all of the different issues and interested constituencies.
Okay, thank you so much. Rose, do you want to add, or should we gather more questions from the audience?
I think we should gather more questions from the audience. If we have time, I just would flag that we've been talking a lot about gender as it relates to persecution. And if there's space and time at the end of this call, I know that Akila would have wonderful things to tell us about gender as it relates to apartheid as well. But I'm just going to put that, perhaps we could circle back to that if there's space, but I'd love to hear from people on the virtual or real floor.
Yeah. So, because there is a question from the online audience, especially on gender apartheid. So people from the room, is that all right if I skip you for a second? Yeah, okay, so we're going to skip you. Okay, it's an anonymous attitude that asks, do you think that the concept of gender apartheid have its spot in the draft as well, with the same legal regime as racial apartheid? Or it will be necessary to develop a separate legal regime? As we know, the situation of Afghanistan is not as similar as it used to be in South Africa. For example, Black people were tolerated in public spaces, but women are completely suppressed. So what do you think?
Over to Akila first.
Yes, Akila, go.
I think this is being shunted to me because I'm a legal advisor for the End Gender Apartheid campaign. So happy to kind of kick this off. as someone who works for the End Gender Apartheid campaign, I think absolutely there hopefully will be a space for gender apartheid within the treaty. I think, there's a lot here that the work has really been led by Afghan and Iranian women who really are looking at how to, they're identifying that there isn't a concept or a legal regime that pinpoints their experience. And so how do we take that lived experience and translate that into law, potentially through the Crimes Against Humanity Treaty, potentially through other processes as well. In terms of the question about whether it's a separate or a different legal regime, we've been advocating for it to be a part of the same legal regime. And I would think of it as we think about genocide, right? For so long, we thought that genocide needed to look exactly like the Holocaust. And it sort of inhibited our views of what is a genocide, where is one occurring. And really, when you look at the factors, and yes, what you're pointing out in terms of there's a range of differences, right? You don't have that same separation, for example, that you saw in South Africa that you do in Afghanistan, where the policies that largely directly target women and girls, but also have really important impacts on LGBTQI individuals, including women and girls who are lesbian, bisexual, trans. The policies put them directly under the hands of their oppressors because they're stuck in the home with the men who are actually deputized by the Taliban to oppress them. And so you don't have that same separation that you saw in South Africa. So you have different factors, certainly, but again, as it is with genocide, or as it is with what apartheid looks like in Israel-Palestine versus what it looked like in South Africa, the way we look at it is that these regimes need to be flexible, because if anything becomes kind of fossilified in the situation that prompted the creation of the norm, then the norm itself doesn't serve the purpose of looking forward towards really identifying what is the core of the abhorrence of the crime, right? When it comes to gender apartheid or apartheid, it's as it's been codified based on the experiences of race in South Africa, it's really about the systems of oppression and domination, in the way that what sets genocide apart is that intent to destroy, even while some of the underlying acts may be the same. And so for us, we've been looking at it as a part of the same legal regime. We'll see where the negotiations take us in terms of how states want to look at is it a same regime or different regime? That I can't say yet, but in terms of the way we view it as part of the same legal regime. And there are high hopes, not, I think, only from those of us who are thinking about it from a legal perspective. And I have to give credit to Rose here, who has written about this concept, I think, in like 2015 in some of her work on ICL, and thinking forward on what other things gender could be included. But, yeah, so I'll leave it there.
Amazing. Thank you. Does anyone else want to comment on this, or would we just leave to the amazing expert that we have on the panel? Okay. So, questions from the room. So I think I'm just going to take up one more question from the in-person room, and then another question from the online room, because we're running short on time, which is very sad because the people from the online room are rocking it. They're just like popping question after question after a very interesting question. So people from the room, okay, step it up. Go, questions. No
Maybe you referring to the.
You can go, Vinicius. That is all right. Go.
I'm a prosecutor, so I always think about evidence. And regarding evidence about persecution and regarding the mens rea, I totally understand why we don't have to have the discussion regarding gender and how we see the perpetrators' view regarding gender. My only question is regarding evidence. From the OTP standpoint, wouldn't it be easier to prove that the perpetrator has violated a human rights norm that protects LGBTIs or sexual orientation and gender, rather than that the perpetrator violated a social understanding in that geographical territory, that in that geographic territory, the social construction of gender does not protect LGBTIs, for example?
So first of all, I can't answer on behalf of the Office of the Prosecutor.
No, of course.
Have an academic hat on today. So I think what you're asking is, wouldn't it be better to bring in the understanding, if I understand correctly, of sexual orientation through that other category, the universally recognized? Is that kind of where you're going with that? Universally recognized under international human rights law?
Yeah, fundamental rights contrary to international law. Yeah.
Right. So I don't know about, like, I cannot answer with respect to the International Criminal Court prosecutors whether they have discussed this or not, because that is the realm of another special advisor, and I'm not that special advisor. But I do suspect that there is some concern that the judges may not view and I don't mean to be putting any words in anyone's mouth, but it's just a suspicion that there may be concern that the judges may not view the law as consolidated as others might view it, in terms of the what international human rights law has to say on sexual orientation and gender identity. And I have a feeling that there's some concerns in that respect. Now, the more time goes on, though, I think that should go down, unless there's some changes, like there's some major pushbacks in international human rights law. But I don't know if that's helpful at all. And perhaps Lily, you probably have more thoughts as well. Lily?
I'm thinking, sorry, if Rose wants to.
I can come in
so-
a little bit on this if we'd like as well, but I didn't mean to talk over if there was somebody else in the room or online.
You never talk over, go.
Well, our questioner was, I think, asking a really important query. I think my two responses, and again, I'm not even a special advisor, so I'm not even pretending to speak on behalf of any institution or not, but I see the value of charging the mens rea itself as being the ideology as an intention to persecute on gender grounds as important in terms of the aims of international criminal justice. I think can't only be securing a conviction, but also making visible the ideologies that enable violence to happen. I think that's why persecution exists as a crime at all, really, is because it was understood from, the Nuremberg Tribunal onwards that, for example, it wouldn't make sense to just describe the mass incarceration and slaughter in gas chambers of people. Like, it had to be couched in terms of anti-Semitism and anti-Roma ideology, etc. And I think that it's really valuable to articulate the reason, the why people are being persecuted, sometimes is gender. I'm not sure that the evidence is always so hard to find of the mens rea, because for other grounds of persecution, an intent to be targeting people because of the ground, ethnic, racial, gender, etc., has been inferred from the pattern of targeting, for example. So if there's a pattern of targeting a lot of people who seem to be LGBTIQ, it can be inferred that that might be one of the reasons why they're being targeted. It can be inferred from the kind of curse words that are uttered by persecutors at the time, verbal utterances, which are often extremely, say, homophobic or sexist or that kind of thing, as well as things like, official dogma and preachings and laws that are imposed. So I think, I'm thinking about the Taliban, for example. I think there's a raft of evidence that the reason that they are targeting people is because of homophobia, because of sexism, and that, as an evidentiary matter, I don't think it need be that difficult to evince that. And as an ask of international criminal justice, I think it's a good ask that they should try and make visible the ideology. That's just my perspective on it, though. Thank you.
Okay, thank you. Akila, do you have anything to add to this or?
I think maybe just very briefly, one thing I've been thinking about as someone who's been working on Afghanistan and thinking about the, what's there in the initial set of what's been asked for of the court is really to take an intersectional approach to kind of the categories that are already defined within, and then to think about how that can advise the evidence of some of the other crimes, right? So in the request for arrest warrants, you have women, girls, and then LGBTQI individuals. But in fact, that category of women and girls includes individuals who are queer, lesbian, bisexual, trans. And so how can you actually, in exposing the violations that are happening, especially because with what's happening in Afghanistan, there's definitely very harsh punishments and criminalization of homosexuality. But a lot of it is intertwined, as Rose is talking about, with gender ideology, right? About what a person is supposed to look like, what are the norms and behaviors they're supposed to be engaged with. And I think that a deeper intersectional analysis, for example, of what's happening with issues of forced marriage, of arbitrary detention and punishment, the types of punishments that are being meted out against LGBTQI individuals, there's a way to also perhaps strengthen that argument rather than thinking about it as three different categories. That's something that's been on my mind as I think of the facts as I know them, of the situation in Afghanistan and what I see reflected in the charges. So I think there's also ways both within persecution and by bringing, I think to Lily's point, a gendered lens to some of the other potential charges that bring a gendered lens, whether you're looking at LGBTQI individuals, you're looking at issues of cis women and girls or some intersection of those, to really maybe more fully encapsulate what's going on in Afghanistan, and hopefully also have, I saw a question in the online chat about Al Hassan, and I would let others maybe answer that, but think about also maybe ways to mitigate perhaps problematic jurisprudence that we now have out of the court as it relates to gender persecution, and think about how we can bring that lens around inclusivity of LGBTQI individuals and those experiences and the crimes that are being committed into perhaps a fuller range of gender-based crimes that occurred.
May I add, to come back to your question, Vinicius? So you talk about element 3, right? So I think there are two strategies. One would be the German example, to go for a separate ground that speaks to sexuality or sexual orientation in that case. I think we have the tools to not do that. I think we have the tools to go through gender, Article 7.3, Article 23.1, and then really pull out human rights law and the understanding of gender, sexuality, gender identity and expression, and sex characteristics in a very clear way where we wouldn't need an additional ground. And I mean, you also need the two other elements like fundamental rights and the targeting of a collective and identity. So I think there are two strategies, and if you're exploring that through research, these would be some of the sources that would be worth exploring. And of course, also, I mean, we haven't mentioned at all, like, for example, Colombia and all the developments there, or any kind of really national jurisprudence outside of the international crimes arena that could provide for guidance as well.
Thank you so much. So I am really sorry, but I have to be punctual. We have amazing questions still on the chat. So we have Patricia Bezerra talking about an expansion of the idea of humanity, Dina Rosenthal talking about what Akila was talking on, really going big and not going small. We also have people, Camille Chateaubrun talking, asking about the Al Hassan judgment and the criminalization of homosexuality. Other people talking about the differences between gender apartheid and gender persecution. We have a lot to discuss still, but we have to come to a close. But before that, I just really wanted to thank everyone that has helped make this event possible. So we have Vanessa and Priscilla from the Lauterbach Center, which are one of the most efficient people I have ever met. Also, Dr. Lauren Wilcox, who's in the audience right there. She's the director of the Gender Center, also one of the most efficient people ever come to know in my life, and Joanna Bush, who have supported very generously the organization of this event. I just also want to thank you for coming. So Lily and Valerie, thank you so much for your amazing engagement, and also Akila and Rose for I don't know what time you are, but thank you so much for joining. I am a huge admirer of everyone's work here, and also for Cindy, who's at the back, and he's the director of the Lauterbach Center, without whom we wouldn't have this this event, because you have generously believed in our proposal and funded it. So thank you.
So thanks to Juliana for her conceptualization of all of this.
Thank you. So thank you so much.